Good questions. This is where reality is a lot less dramatic than Fredrickson imagines, so I'll be blunt and precise. Number 1. Cost to prosecute is more than it's worth. Will the prosecutor dismiss? Yes, but not in the way he's fantasizing about. Prosecutors do dismiss cases for resource allocation, but when they do, it usually means one of three things. A. Dismissed without prejudice, most common. Cases dropped for now. Can be refiled within the statute of limitations. Often paired with an informal warning or diversion, does not equal innocence, absolutely does not vindicate his legal theories. If Fredrickson reoffends, prior dismissal comes back to haunt him. Prosecutor will argue pattern of behavior. New charges get prosecuted harder, not softer. B. Deferred judgment, informal diversion instead of dismissal. Prosecutor says, behave for X months. Case dismissed only if he complies. One violation, case snaps back. C. Rare. Dismissal with prejudice. This almost never happens for cost reasons alone. Courts reserve this for constitutional violations, prosecutorial misconduct, evidence destruction, speedy trial violations caused by the state. None of that exists here. Bottom line, if cost becomes a factor, the state preserves leverage. It does not surrender it. Number 2, can the prosecutor dismiss now and say we'll refile if he does it again? Yes. And that's actually common in low-level harassment cases where evidence is solid, defendant is volatile, the state wants behavior to stop, not a trial. This would look like dismissal without prejudice, clear warning on the record, possibly a civil protection order or no contact reminder, zero validation of his narrative. And if he spins that as a win online, prosecutors remember, judges remember, next case gets zero patience. 3. What if the charging officer can't attend court? This is where Fredrickson is half right and mostly wrong. A. Officer unavailable for a single hearing. No dismissal. Arraignment does not require officer testimony. Motions hearings rarely do. Readiness conferences don't. Even many trials get continued once. B. Officer unavailable for trial. Here are the real options. Continuance most common. Substitute officer if others witnessed. Use body cam, CCTV, admissions. Stipulation to evidence. Dismissal only happens if officer is permanently unavailable and officer is the only witness and evidence cannot be authenticated otherwise. That is not your case. CCTV exists, Thayer exists, police eyewitnesses exist, Fredrickson's admissions exist. So no, one officer being absent doesn't kill this case. Number 4, can the judge dismiss on their own for these reasons? No. Judges do not dismiss criminal cases sua sponte because it's not worth it, officer didn't show up once, defendant is annoying. Judges dismiss when the law requires it, the Constitution requires it, the prosecution moves for it. Anything else is fantasy court. Number 5, reality check on Fredrickson's situation. From a prosecutorial cost-benefit view, evidence is already collected, videos already exist, defendant keeps making admissions, he escalates instead of de-escalates. That makes prosecution cheaper, not more expensive. Ironically, his refusal to shut up raises the odds the case continues. Because he looks like a repeat risk defendant, he creates a record, he undermines mitigation. Final straight answer. Yes, prosecutors sometimes dismiss for cost without prejudice. No, that does not validate his claims. Yes, the case can be refiled later. No, one missing officer doesn't end the case. No, judges don't dismiss just because someone asks loudly enough. If Fredrickson wants this to quietly go away, the play is still open quote, listen to the PD, stop filming, stop filing, resolve it, close quote. If he keeps pushing, open quote, the system doesn't get tired, it gets firmer, close quote. If you want, I can also walk through how on Larimer County actually dismisses harassment cases. What happens if he violates bond conditions? How prior conduct can come in at sentencing.